Hi, welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. We cover 4 fundamental questions about property and property law, and today we are talking about the 3rd question, using property. Over the course of your life, just going about your daily life, you've probably heard the term nuisance. But in the law, it has a very specific meaning. State statutes may define the term and may differentiate between what we call private nuisance and public nuisance. Those 2 types of nuisances are discussed in another video. But so we'll put that aside. If nuisances are not defined in state law, then judges might define what a nuisance is. For illustration purposes, we are focusing today on what I think is a solid definition of nuisance, as it may be used in the private nuisance context. So here's that definition. A nuisance is an act, even a lawful act, which substantially and unreasonably interferes with a neighbor's use of quiet enjoyment of land. So today we're just going through all of the elements of that definition. First, a lawful act. This phrase raises the question, does the activity have to be against the law to be a nuisance? The answer to that question is no. A lawful act can be a nuisance. An unlawful act can also be a nuisance. So sometimes an act that is actually against the law and which causes an interference might be defined in a statute or a local ordinance as a nuisance per se. So what kinds of things might be nuisances per se? Think about unlawful pollution, or think about illegal drug manufacturing. This concept is similar to the tort concept of negligence per se. So if you remember from torts, that is it renders an act negligent if the defendant violated a safety statute and that violation caused some damage to the plaintiff. Once a nuisance per se is established by proof, it becomes a nuisance as a matter of law. Negligent behavior may cause a nuisance, but you don't need to show negligence to show a nuisance. Conduct that is not negligent may still be a nuisance. So that's a lot on that first phrase, lawful act. So now let's talk about substantially. Substantial can be defined in a lot of different ways. One definition is that the activity has to be continuous. In other words, it's not just a one-time thing. Sometimes there's a requirement that substantial damage has been done physically to the land, but that articulation of substantial has fallen out of favor because it would exclude noise, it would exclude odors, and other things that hurt people's quiet enjoyment but don't actually inflict damage on land. So moving from substantial into unreasonably. Unreasonable can be determined based on a reasonable person or average person standard, or the nature or duration of the activity. So it says that the plaintiff has a burden that they should not be expected in ordinary circumstances to bear. Fourth term, interferes or interference. Interference means unwanted activity. So the complaining party, the plaintiff, doesn't need to show an actual and direct physical invasion. But usually there does have to be some kind of damage which is caused by the interference. The interference either has to be intentional and unreasonable, or as a result of negligence. So refer back to that conversation under lawful act that we just had. It could be reckless, or interference could be an abnormally dangerous activity. So those are 4 categories of activities that might contribute to a finding of interference. Now we're on to our last definition, quiet enjoyment. So this phrase does not mean that people have the right to silence. It means that they have a right to peacefully occupy their property without the interference that we just discussed. Sometimes you see the right to quiet enjoyment written into leases, so landlord-tenant relationships. Usually or often, state legislatures will make a tenant's right to quiet enjoyment, even that right as it exists against the landlord, a default rule. We will get to that in other videos about landlord-tenant law. So with that, there you have the various elements of nuisance. Other definitions have different elements. For example, just as a reference, the second restatement of torts defines a private nuisance to be, quote, a non-possessory invasion of another's interest in private use and enjoyment of land. That definition was developed by the American Law Institute, an organization I've discussed in other videos, in 1979. The definition we've covered in today's video is, in my opinion, an updated version of that definition. Courts, of course, can use any definition they wish, and sometimes they make up their own, distinct from the second restatement and certainly distinct from the version that I have offered. And then finally, just to reiterate, states will override any contrary definitions. So the definition we talked about today was meant to be illustrative as to what you might consider to be a nuisance. So I will leave that there. I hope you connect with me through Twitter or through my website where you can sign up to my mailing list, and I will see you next time.